Of the College of Law's Entrepreneurship and Innovation Program, I welcome each and every one of you to our second Global Entrepreneurship Week celebration. Global Entrepreneurship Week is 1 week in November when thousands of events and competitions around the world are hosted to inspire millions to engage in entrepreneurial activity. At the same time, it is an opportunity to connect entrepreneurs, students, faculty, staff, and members of the community with potential collaborators, mentors, and investors. GEW Week events are powered by the Ewing Marion Kauffman Foundation with its network of 24,000 partnering organizations in 115 countries with over 37,000 activities that engage 7 million people. Here's a glimpse of what is happening around the world.
Now is the time for entrepreneurship.
We are committed to foster entrepreneurship and innovation in Chile.
Being part of Global Entrepreneurship Week is a great opportunity for everybody to come together and form that voice.
Global Entrepreneurship Week is a little adrenaline in the arm for the community of organizations and networks that make up the entrepreneurial community to say once a year we're going to make sure we celebrate.
In Denmark, we will now focus on renewed growth and entrepreneurship. We have to encourage everybody with an idea, the right motivation, and the will to become an entrepreneur to pursue their dreams.
Last year, over 120 events took part all over the Netherlands.
有上百万的中国青年人被吸引到这项活动中来。
It has been the risk takers, the doers, the makers of things who have carried us up the long, rugged path toward prosperity and freedom.
Global Entrepreneurship Week will be going off in almost every country in the world 5 years from now. Probably 500 million people in 1 week will think about a different career for themselves. They will see in Global Entrepreneurship Week a moment, a second, a day, a lecture, a TV show, a program in which they reconceived of what they were going to do with their lives.
It's amazing. This year, the College of Law's Entrepreneurship and Innovation program continues a tradition of celebrating entrepreneurship by engaging you with today's event. We begin our conversation on patents, global innovation, and the role of the USPTO. During this week, we also commend the 20 semifinalists, competitors in the West Virginia statewide business plan competition hosted in Charleston. And this happened yesterday. Each student is vying to win one of two categories, lifestyle and innovation, and hospitality and tourism. We wish them the best on their new business ventures. Now, today's programs are being distributed by students, so if you have not received a copy of the program, just please let one of the students in the program know. I now turn the program over to Sean Tu, Associate Professor here at WVU College of Law, who will introduce the speaker in our legal topic today.
So it's my pleasure today to introduce Mr. Kery Fries. This introduction will oddly begin with how we were introduced. I first talked to Mr. Frese when I called the PTO hotline. Just to give you an idea, whenever I have an idea for an article or whenever I get stumped with how to get a particular piece of information, I call the PTO hotline. And that day, as always, the hotline was produced great information for me. And Mr. Frese was the one who was manning that on that day. And I was really just amazed at how encyclopedic their knowledge is at OPLA. And now I understand why. As an initial matter, Mr. Frese has almost 20 years of experience at the PTO, and he's done almost everything at the PTO. He started as an examiner in Art Unit 1751, which deals with chemical compositions and is one of the toughest art units out there. I know that he's issued over 156 patents as a primary examiner over the course of 5 years, which makes him one of the more prolific examiners. And then he moved on to do a detail at the BPAI, the Board of Patent Appeals and Interferences, where he was an actually an administrative law judge dealing with patents. And currently, Mr. Frese is a senior legal advisor for the Office of Patent Legal Administration and the Office of the Deputy Commissioner for Patent Examination Policy. So Mr. Frese has really done it all at the PTO, from being an examiner to a legal advisor to an actual administrative judge at the PTO. Additionally, Mr. Frese has had some of the best IP training in the country. I would like to think, but I don't know, that this interest was first sparked when he was a student here at WVU, where he actually took an IP course with Professor Olson. He then went on, so if that was the spark, he then went on to grow that flame at one of the premier institutions, Franklin Pierce Law School, which is one of the premier schools for patent law. And finally, Mr. Frese went on to get an LLM at George Washington University, which is, again, one of the premier institutions for patent law, where Chief Judge Rader of the Federal Circuit actually teaches, and Dean John Whelan, ex-Solicitor General at the PTO, currently teaches. Again, one of the, he's gotten his education at two of the premier IP institutes in the country. With this said, we are really lucky today to have Mr. Frese here. This is especially true in light of the topic that he's discussing, which is the new American Invents Act, which has been touted as one of the most significant changes in patent law since 1952. This act is, although this act isn't poorly written, it has many ambiguities that are open for interpretation, and no doubt will be litigated. So without further ado, I'm really excited to present Mr. Kery Fries.
Good afternoon. Let me first say with great pleasure, I'm back to my old stomping grounds. I was really excited to come here. I go all over the country, speak to a lot of universities, a lot of bar associations. But I can honestly say that I've looked forward to this one more than almost any, because this is like me 1986 to 1989. So it's a thrill for me to be here today and talk to the students, especially on a topic such as innovation. In innovation, I will say this, that the field of patent has really burgeoned in the last 10 years because the value for the United States companies is in its intellectual property, its intangible assets. You see that in patents and your copyrights, your trademarks, your trade secrets. One of the main ways that we protect ourselves is through these type of protections so that others can't use it without our permissions. And that is actually constitutionally based. The patent system is actually part of the U.S. Constitution, so it goes back to the foundation of the beginning. And basically, rather than compete basically on advertising, in many ways, by protecting our ideas and our inventions, that is the quid pro quo for the idea. Without those protections, then society as a whole, at least in my opinion, would not grow to the level and extent that it would, because there wouldn't be the financial incentives that the patent system provides. In terms of the IP globally, I was just looking on the Wall Street Journal this morning, and there was a big article concerning copyright and trademarks. And actually, Congress is debating a Millennium Agreement, copyright agreement in 1998. One of the concerns is of the music industry, and some of the Hollywood studios is that websites are copying, and rogue websites are copying the inventions and doing it for free. So they're debating in Congress in terms of trying to tighten up the enforcement of these areas. And what are they doing? Well, that brings in the other side of the coin, which are the website providers, who basically would be more liable in some ways. So as you can see, and this is a global thing because many of the websites that they're complaining about are outside of the U.S. enforcement overseas. So the question is, how does IP impact globally? Well, that's a prime example in this morning's Wall Street Journal. Another area is patents itself. We have, in the last 10 to 15 years, have really increased our multilateral agreements with other countries. Our laws are somewhat different and it's territorial, but anymore, if you're only protecting yourself in the United States, then you may be losing out because of the marketing and some of the other industries that can just go offshore if you don't protect globally. So we've reached many agreements with many countries in order to facilitate cooperation between our countries. We have what's called a PPH, which is a patent agreement system, with 30 countries right now, including most recently the Chinese and the U.S. signed a cooperative agreement on basically working together to make it easier to facilitate cooperation in both countries. And this is really important because, and anymore, patents are not just national, they're actually global. And the importance of having protection worldwide increases as the commerce lines expand out and out. If you look at patents nationally, you'll see one of the areas of the incentives in patents. In the last month to 2 months, you'll see Nortel. Nortel was bankrupt. But yet, if the company would have valued its assets and its patents, it may not have been bankrupt. What happened was, in the sale of their patent portfolio, they actually made $4.5 billion. That was the incentive of the patent portfolio. And recently, if you look at Motorola, anybody have a Motorola phone? Probably, you actually do have a few. Motorola sold much of its patent portfolio to Google for $12.5 billion. So you can see the incentives in many of these companies for this type of patents in some areas, the actual monetary gain to these, especially in the phones. Everybody's got a smartphone, and the smartphones are probably some of the most aggressively fought between all of the groups. Once you see there's many litigations going on between these smartphones because they're a huge part of the industry and everybody's trying to get the gain. And one of the ways they're trying to gain advantage as to other parts of the industry is through patents. So patents have become very, very valuable in that. Litigation is very expensive. And so according to that, the economic considerations are just very, very important like it used to be. Litigation in the patent field is up because there's value to the patents and therefore more people are concerned. There's actually now also another agencies that become very important to the industries too, which is the Department of Justice. Patents and antitrust have somewhat of a tension because what a patent does is prevent others from making, using, selling, offering to sell, or importing for a period of 20 years. And antitrust is basically saying you shouldn't monopolize, you shouldn't. So you can see the basic tensions between the two systems. And sure enough, the Department of Justice decided that they wanted to review some of the patent portfolios to determine whether or not there's any violation of antitrust with the Google sale of Motorola or the group that bid for the Nortel products. So the whole IP has basically become such a huge part of our gross domestic product that there is a very big incentive to have the intangible assets. For a long time, it was hard to see. What is a patent? What is a trademark? What is a copyright? What is a trade secret? Whereas the difference, if you manufactured a car, you could see the car. So you valued the car, but you didn't so necessarily as much value these intangible assets that we have. A few years ago, a new player got into the game called Intellectual Ventures. Has anybody heard of Intellectual Ventures? Intellectual Ventures is a patent buying agency. So what Intellectual Ventures does is they actually take inventors and buy patents up. So then they put portfolios together and they go to companies that use their industry and saying, we have a portfolio of these patents and we want to license these patents to your industry so that you can use them without consequence in exchange for a payment amount of X. I read recently that Intellectual Ventures went out and spent at least over $1 billion in acquiring certain patents. So for recent industries, we now have a new group that actually is not, that's actually with asset to actually take these type of industries and patents and take them and buy them from inventors who may not have the wherewithal or the financial means to support themselves, and then they can get licensing for these big industries. So as you can see, the whole system is really, really grown, and it's going to continue to grow in this field. And anyone that's interested in this field, it's still a lot of opportunities. At the Patent and Trademark Office ourselves, we actually have a budget of $2.7 billion to run the agency. We are behind a number of patents of over 700,000 is in our backlog. And we intend to hire 1,500 people per year for upwards of 3 years in order to address the amount of volume of patents that we are received in the system. If you look at other industries that have taken a great concern with the patent system, it's actually the Supreme Court. For years, the Supreme Court really, really was inactive when it came to the patent field. But I would say, and Professor Tu would tell you, and what would you say, sir, in the last 5 years? In at least the last 5 years, you have seen the Supreme Court taking more and more of patent cases because of the impact on industry. I have seen the case, let's see, 103 obviousness. That was a case about what is the standard of a patent and what's obvious over another patent. We also had the Bilski case, which is a 101 case. In patents, one of the things you have to have is utility. And the question in Bilski was, if you do a computer implemented program or whatever they wanted to do, is that in itself a 101 to get you through the initial threshold door? Recently, the Supreme Court addressed the issue of whether or not, what was the last one? Seagate was damages. They also addressed, I can't recall the last one, but right now they have another one on their docket, which is basically one of our cases that we asked them to review, and myself and our solicitor's office asked them to review the ability of a district court action if someone can create a brand new record once they get to the district court rather than having to present that evidence in front of our agency. The Supreme Court has found a lot of interest in these cases and are now taking them up. In addition, the third leg of Congress, the branch of the government, the Congress has now decided that they have an interest in the patent system as well. And over the last 6 or 7 years, you will see bills being introduced to change the patent system. And recently, in September of this year, it has finally happened. So for the first time since 1952, we had tremendous changes to our patent system. And it was a bargain for exchange between many industries that felt this was important versus that important. And what you have is a great divide. In some industries, such as I would say maybe the computer industries, you have a short shelf life for invention. So what you need in these short shelf life industries is quick decisions and quick reviews. But more in the biotechnology industry, your concern is over the long term of the patent, because what happens is they buy the entire term of the patent for 20 years. So you have a great divide about different industries wanting different concerns about how the patent system works. Based upon that, we get to where we got to today, which is what did Congress end up doing to the patent system? The first, and I would say at least since 1952, and maybe even, well, I don't know anything as precedent as what they did. So obviously you have the executive branch, the legislative branch, and the judicial branch all taking great interest in the system and all taking a great interest more than ever, and globally a great interest in making sure. One of the countries that has taken the biggest interest in patents recently is China. China has a 5-year plan, a global plan, in order to really, really enhance their patent system. And I think it's the master plan of 2010 to 2015. But actually, China has more applications filed than the U.S. now in terms of actual applications. So you can see this is not just a U.S. industry, it is a worldwide industry. And impact in other part of the global has impact to us. For instance, recently the European system said that they would ban some type of biotech patenting. Well, the impact of that is it's either going to come to the United States or it will go to Asia, because the industries that want to do research and development in this area will want to go where they're protected. And if you don't protect those type of industries with patent laws and decisions, then there will be no incentive for them to do it. And that is one of the cases that we have, which is a genetic. Anybody heard of the Myriad case? Well, one of the cases of Myriad is a case in which the question under 101, patentability of gene patenting. And that is raised probably more debate and review than probably any case I've seen in the last 10 years. And Australia looked into the gene patenting as well. And Australia ultimately decided that they were going to provide for the patentability of the gene patent. The Europeans took a different position. We should come to certain human. And in fact, we actually banned human organism patenting, and we have done that since at least '87. And we don't deem gene patents to be in that category. Now what we did, because this is such a big thing, we focused on the organization, and we got, because this impacted money, it impacted patents, it impacted the Board of Appeals, we actually did a working group just to work through this legislation. It was so big that we needed to expand out and compartmentalize this particular change. Some of the things that we did to get public input, because when you have a major change like this, you can't have a top-down system. You have to ask your customers, your people that use the system, is this good or bad, and how can we do this, and give us your opinion. So we have gone out with this administration expressly to ask many inputs from our user communities in order to get these responses. So we had stakeholder meetings. We had people come to the office and assert their positions. We have a notice and comment rule making. We have a public roundtable. We have a website that we use daily to update so that people can inform, because we have a schedule that we have to deal with just to get through this law. Our website is right here under USPTO.gov, and anything about the new law that we're working on, we publicly expose it in this website for comment and public review. And this is how big it is. We actually had a lot of different staging of the actual act. Some of the things that went into effect immediately, such as changes to reexamination. We have a requirement of preventing certain tax strategy patents. There was an interest in certain parts of the industry not to have certain tax patents. Human organism prohibition, false markings. Anybody know about the false marking? False marking became a big thing in the last year. What that is have you ever been to the grocery store and you see a patent on a product? Well, that's the number of the product. Well, what happened is companies didn't remove that after the patent expired. So there was an easy way for people to be sued under this number, because if it wasn't taken off, there was a statute that said provided a remedy for anybody who could file it was very broad. So you started seeing a lot of these false marking suits. And then companies were getting hit with millions of dollars for allegedly not allegedly, actually having a expired patent number on a patent. So Congress decided that was important enough to deal with, and they actually changed that to have a virtual marketing, which you can do differently. We have because we moved to a different location, we changed where our suits are. And also there was an OED statute of limitations against certain attorneys' actions that they went into effect on the day one. And we had new fee-setting authority. Then 10 days later, we went into prioritized exam. And I'm just going to barely go through some of this because it's minutiae of detail, but overall, we have electronic filing incentive. And then 1 year from now, all these other particular ones kick in, and finally at 18 months. So you can imagine all the rules that we have to implement to enforce these statutes. It has been very, very strict time limits and very lot of timing because of the requirements of the change, which is very big. Under the first thing we got was the fee setting. Right now, we have a business model that basically says the back end supports the front end. And the model is such that when you file your patent application, it's about $500 to file it. And that's all you have to pay in front of us if you do everything in a timely manner until you get it issued. And at that point, the most you pay is another $1,000. So from the office, you got about $1,500 in the patent, or $1,600. Where we actually recoup some of the revenue for that is the paying of maintenance fees. So the model is we want to make it inexpensive to get through the door, and then later for people that use the system and actually receive reward, that'll compensate for some of that. And it was by statute, and it requires a certain amount of money to be paid overall. Now they have set authority that we can make changes to some of those actual fees and make our own adjustments, but we got to get approval from which we're going to do. We also created what's called a micro entity. And that is basically a 75% discount on our fees. So rather than, if you're a large entity and you pay $1,000 plus $2,600 for that, 75% discount, you would be paying them maybe $300 to $500 for your patent. And the reason is we want to encourage small businesses to have a patent, because what we've heard from small businesses is the following. I'm trying to get investment money. I'm trying to get venture capital. I can't get venture capital till I get a patent. It's a vicious cycle. So in order to do that, we want to make it reasonably priced so that they can get the patent, which is what they need to go to the venture capitalist and get the money to support their small business to make it grow. So we're supportive of that. One of the institutions actually included in the micro entity is universities. So universities will qualify for the discounted fee. It will go into effect after a rulemaking period, so it won't be long. At some point, we will have 3 separate entities, which is large, small, and now this what's called a micro entity. 10 days later, we increased the fee for 15%. Part of the fee increases is to support the new examiners, because we want to get the background down. We want to increase the number of examiners, so we're trying to do that. And one of the programs the same day we created was called the prioritized exam. What that is a system in which, because we have 700,000 applications in the backlog, you can move to the front of the line. If it's important enough, and in some cases it actually is important enough, to go ahead and get your patent exam in priority time, and the reason is because you want to get your venture capital, we have created a system by paying this fee up to 10,000 apps a year. You can move to the line and you can get your exam in ahead of some of the others in the backlog. And small entities actually get a 50% discount. So for someone who is venture capital saying your idea is great, your idea is great, your idea is great, but where's your patent? We have a program that says, okay, for you, $2,400 plus your fees, your normal fees, we'll have you examined up front. And basically we try to do those cases in a year, because with the backlog sometimes it can take 3 and 4 years, and for some industries with the venture capital that can be too long. So in those particular situations, we are trying to create special programs. One of the other areas we have something similar to this is green tech. We tried to encourage the green tech industries. So they didn't have to pay a fee, but if you could show that your patent was in a certain area, the green tech would come in and we would move you to the front of the line. And we would say we would do that to up to 3,000 applications. And the incentives were, they would, the same thing. Green tech said, I needed my patent to go out and sell it for investment interest. And because of the worthwhileness of that, we've seen a lot of people with car batteries trying to improve electric cars, algae as energy. You're seeing a lot of different areas in the biotech coming in and trying to basically get the business to increase their business and hopefully overall have a system which the United States benefits by growing burgeoning industry of green tech. The filing incentive, we want to encourage electronic filing. So as of today, actually, is today the 15th? Day the 17th. Well, I'm glad I wasn't at the office yesterday because that extra $400 if you pay by paper was making some phone calls. So it's kind of good to be on the circuit today. There is a reserve fund, too, because what happened was the way our budget works is we get the money in, and Congress tells how much we can keep. And then we don't get any money. We have no taxpayers' money. All of our money comes from our user fees. So at the end of the year, the amount of money that we're allowed to spend is measured against the amount of money that we earned. And if there was an excess amount of money, that wouldn't go into any of our funds. That would actually go to the general treasury. And over years, that was about $900 million that couldn't go to the patent office, would go to the general treasury. So in some ways, we believe that's a tax on innovation because we can't use that money to help our industries because it's being used for general purposes. So in 2000, October 1, Congress says, well, we'll let you have your own reserve fund. So we're going to have a reserve fund. And Congress will tell us when we can reserve our reserve fund, but the money won't go to the general treasury in helping innovation, and it won't be going to different places. One of the other things happened is reexams. Anybody understand what a reexam is? Well, a reexam is where someone says, I don't believe that patent was worthwhile. I want you to review that. So that is a debate upon the patent owners versus the third-party requesters. So there is a tension between those parties, and if we have a low threshold, that means third parties can come in regularly, and there's a concern about harassment of the patent owners. If there's too high of a threshold, there is a concern that patent owners could basically go to exercise license against third parties with very few remedies for them to have it addressed. So what we actually did in this particular case is we did raise the threshold, which was a benefit to a patent owner because the threshold went from what's called a substantial question of patentability. And I'm sure all of you legally or in law school understand that now you got a different threshold, which is a reasonable likelihood of success type. So you've upward the threshold. So the burden of the person asserting now has been increased, which makes it less likely in order to have a reexam requested. The other thing we've done is tax strategies. We now not allow a patent, which the sole reason for the patent would be because the tax strategy itself is not novel or obvious. So Congress had a concern with tax patent strategy patents, so they actually enacted a statute that did that. The best mode. One of the requirements of a patent is a best mode. What is that? Well, that basically says in exchange for your 20 years of protection, you have to tell me the best way you've done that. Because that's for public disclosure, public notice. So by pieing the public, that's how the advancement of society, the quid pro quo for this 20 years of protection, is that you tell us the best methods to do what you do. Well, in this particular act, there no longer can be, a patent owner cannot be sued if that best mode was not disclosed to us, but that doesn't have impact on our examination. We still require you to tell us that is the quid pro quo for the thing. One of the other parts of the rulemaking is you're not going to have human organisms. And we say that that was just a codification of what we did because we wouldn't allow patents to do that type of thing anyway. Patent term drug extensions. I don't know if anybody's heard of the case of, well, some people called it the dog ate my homework case. What happened was, in this particular case, you're required to come to the federal government in 60 days and file for an extension of this patent. What happened is the filing was day 63. The unfortunate part of the filing was that by going a couple days beyond, that they could no longer get an extension of over 4 years. And what that meant was a certain licensing amount of $250 million a year times 4 point some years. The actual 2 days of consequence cost $1.2 billion to the industry. So you can see sometimes, and you're in certain parts of it, and some of you lawyers out there, make sure you know deadlines, because deadlines can come back to haunt you. And one of the importance, especially if it's a statutory deadline, and if you have a statutory deadline, none of us little agencies can overrule them. We can waive rules, but we can't waive statutes. So as a good lesson for everyone here, a statutory deadline is a specific deadline that you have to meet. As I mentioned about false marking, we tried to prevent some of the suits against our industries by allowing a virtual marking. The other things we did, we changed some other parts of the things, and they're going to go in effect in 1 year. And the oath or deck, we made it a little simpler to file the oath or decks. One of the requirements of the oath or deck is the inventor, sign these particular oaths or deck. One of the other requirements in a reissue is that you tell us the reason you're coming back is not because of deceptive intent. We've sort of eliminated that because we want less reasons to have litigation. So we're trying to lessen the litigation issues, and therefore we're not requiring the deceptive intent mark. Third-party submission of prior art. This was a bargain for. One of the things when you file a patent is you want to have as much patent reviewed as possible. So by having third-party industries that are aware of that industry submit art to us, we can actually review not only our own search, but we get the benefit of another person's interest in that area. So we allow third parties to come in and tell us what they know about that particular patent application. And by doing that, we've expanded the time frame, so now we're entitled to the benefit of more and more of participation by parties other than the patent owner. We had a project by New York University called Peer-to-Peer, and what that project dealt with was basically industries would say, okay, I want this patent airtight, so what I'm going to do is open this one up for peer review by anyone in the world wide who had an interest in reviewing my claims and finding prior art. This is similar to that in the extent that although it's not a particular university in the project, any third-party entity that have an interest would submit it to the patent office, and our examiners would consider that. The same thing with citation in a file. Sometimes an applicant takes a statement in a litigation proceeding as to claim construction, so now they're going to allow that to be put into the patent file. More again, to have the quality. Once again, they also tell us that we can create our prioritized examination for industries. We've done that for green tech. Who knows, in the future, there maybe we need to promote some particular industry to, for the United States gross domestic product, whatever. By doing this by statute, now we have the authority to do what we've been doing by rule. Supplemental examination. Anybody gets in a patent suit, here's what happens. One of the first, Professor, you can probably tell me this, right? How many times has your firm, you've seen a defense of inequitable conduct? 100% of the cases, right? After Theresense, it may go down some, but still, that was a great defense strategy, right? So, what the patent owner said is, we like to have a mechanism in which, so that they can't use that defense strategy, we can come back to the patent office, as long as it's not fraud, and we can submit that information to us for your review. And if it's actually reviewed and validated again, they will not be able to allege in a district court action or any civil action that the patent is invalid because of inequitable conduct. So this is going to be a big benefit to the industries that will use this are the patent owners themselves. The venture capitalists, if you're going to buy a portfolio, one of the things that you may want to do is you may want to have industries come in, and if they think something that would be important enough, they would put it back on our record so that it can't be later used against them in litigation. It creates certainty in the patents, which increases the value of the patents. Here's the time frame of Interpartes review, which is the third party's way to come in and say, I don't think that patent should have been granted. One of the things that people use as a strategy is, as lawyers, you guys know there's always burdens of proof. When it comes to administrative proceedings, the burden of proof for someone submitting a request for the office to review it is a lower threshold than if they're trying to present invalidity in court. So one of the strategies is come to the office where there's no presumption of validity, and I don't have the burden because it's administrative agency reviewing it. And in lieu of that, the problem is that can create some type of what we deem patent owner harassment. Because if you keep coming back to the office and on cycle and cycle, keep promoting. So what they actually did as a bargain exchange, they lowered the threshold to get into the door. So now the threshold in what's called a substantial question, because that would just be what's important to an examiner. Now the threshold is there a reasonable likelihood that the requester would prevail at least one claim. So we upped the threshold, we made it harder to get through the door, and therefore the patent owners are more comfortable in the fact that not every case is going to be continually litigated in front of an administrative agency. Also, the granting interparty, the same thing. 1 year from now, that goes away, and we have a new procedure called Interpartes review. Rather than the department I work in handles those, it'll be handled by the Board of Patent Appeals and Interferences. So it'll be judicial-based and a lot more evidence-based. So you're going to see a little bit of change in what happens in those types of proceedings. One of the things that happens in these exams is, in order to prevent the patent owner, we got a provision called estoppel. Everybody's heard of estoppels, right? You've been in law school. Estoppel says, okay, you took your best shot. Now, you're not going to continue to do that. You're going to be stopped from future making the same assertions because it went through the agency, and now we're not going to allow you in a district court or an ITC proceeding to re-litigate or re-discuss the same thing that you do. So a third-party requester has to consider the effect of this estoppel, whether or not they want to file that inter-party review or whether they'd rather take their chances in these type of other proceedings. And that is the balanced exchange between the program of allowing review of patents after they're issued versus the consequences of coming in the door. The PostGrant is another proceeding that we didn't have before. One of the differences here is under the patent law, you could request a review based on a patent or printed publication. That was basically the scope of what you could do. Now, third parties have the right to come in under issues beyond that, including like 101, should it get a patent at all? 112, is it clear and definite and enabled? So post-grant review is for a limited window after patent issue for that period, and 9 months. Who can file a third party? Patent owner is not going to file it against itself, so only a third party is going to come in and file such. And then once again, same as the other, we have the trade-off. We have the estoppel provision that prevents unlimited review. Covered business method. One of the industries that really is complained about some of the patents is the software industry. And they complain because somewhere in the software industry believe there is some open source. Some of you understand there's open source. They don't believe in the patenting. So there is a great divide and a great dispute in the industry whether software should be patentable. And there is a small industry that disputes the fact that there should even be granted such. Of course, as a patent office, we believe it should be patentable. But some in industries, or at least some restrictions. So there is a great debate with Bilski and a few other cases, Entrepreneurship recent case, that deals with what are the lines and boundaries of just 101, can you get through the original threshold? And that is a debate, continues to be a debate. What they have done is allowed review of these type of patents in a post-issue procedure in which you can challenge them, and to not only that, but for a period of time, up to 8 years where we're going to sunset the provision. And one of the differences is, under this method, you can go back to the patents before 99. See, under the present system, we could only review 99 forward. So it's going to open up a broader threshold of patents for review. Once again, they're also going to have the estoppel because that's the trade-off. If you come to the procedure, you're not going to have unlimited bites of different proceedings. And last, one of the big changes is the first-to-file system. First inventor to file. Let me correct myself. We presently have a system called first to invent. In 18 months, we'll change to a first inventor to file. That doesn't necessarily mean the race to the courthouse will always win. There are scenarios where the race to the courthouse still won't win. But it'll be different in small inventors who have concern or get patents. Will have to definitely think a little bit differently in terms of how they want to protect and concern about sales, etc., because impacts will definitely be changed. The transition will be 18. It's going to be basically 18 months before first inventor comes into effect at all. So we won't see it as of any patent issuing now. It's still under first to invent. But starting on March 16, 2013, any patent filed after, any application filed out will be subjected to the new term. There is a concern about this, so we have to do some studies and reviews, a sense of Congress, whether the first inventor to file is the system that we're going to stick with. I believe that everybody wants that it'll be proper, but again, we have review. There is a big debate. It's probably one of the most contentious things in the whole bill was first to file versus first to invent. The interference practice will still be here for a while. Interference is when two people claim the same thing, so we have to figure out who is the first to invent, concept, and reduce the practice. Derivation proceedings won't go away. That's a simpler proceeding about who actually invented it and did someone try to derive it from someone else. We're still going to have those type of proceedings. What else are we studying? One of the things we're going to study is this whole list of things that Congress put in there is, if you don't want to change the law, you study it. So we have a lot of studies. One of the things we're going to study is prior user rights. The other thing is we're going to have satellite offices. We opened up one satellite office in Detroit. That was our very first one. And as you can imagine, there is an interest in the other ones. As of right now, I've heard 14 different states have come to said, you put the second one here, you put the third one here. So we shall see, but it's very big interest of where these are going to go. And we are the lead on that. Also, here's one that's really small business. If you have a concern about the program, if you're a small business, their Small Business Administration is going to run a study of the system to see if the switch is a good system. And we're also studying patent litigation. There is a complaint about patent litigation. And anybody heard of an entity called a troll? Trolls? Non-practicing entity is what is it? I guess it's the less derogatory term. Non-practicing entities. And there is a concern that the non-practicing entities are driving up the cost of all this stuff because, they're suing us and, we're suing. So they're going to do a study to determine whether the NPEs have a positive or negative impact on the industry. Also, the office is going to look whether there is a pro bono program to assist Inventors Association. So one of the things we're tasked to do is to spread the pro bono message and help set up institutions so that inventors all over the country that don't have the resources can get help. So we actually have some working with some, and I think we're working with West Virginia, at least through the trademark side as of right now. So we have the trademark help in the thing. And then with certain law schools, we actually have a patent program through the universities pro bono to help with those as well. There's the timeline of all the changes. As you can see, we got a lot to do and a lot of time, not very much time to do it. And some of the publications that we did. That's all of my formal presentation. They asked me if I wanted to take any questions. I'd be happy to.
You briefly mentioned it, but what do you think that the patent trolls have effect right now, and what do you think will have effect on with the new legislation?
Well, one of the things the legislation wasn't mentioned here is there is a limitation about whether they can do joint actions versus. So that will have an impact because rather than sue 20 people, they're going to have to individualize the suits. That's going to cut back on the patent entity. I really don't take a position whether it's positive or negative. And I can see, I can see an inventor saying, I now have somebody I can sell my patents to, rather than industries that say, well, I don't want to license that. Well, if you don't have anybody that wants to buy it and you can't enforce it, then you have the problem of that. On the reverse side, sometimes there has been some criticism of targeting of certain ones. So balancing, I think it's a development that occurred that I think people weren't aware of, and I think it's going to sort itself out over time.
I was curious a little bit about the satellite offices.
Mm-hmm.
Can you tell me a little bit more about them, what they would do with examination happen there? Or?
Yeah, exactly. It would be a mini patent office, mini Alexandria, Virginia. Okay. So we're going to put those in 3 different parts. One of the reasons why we're doing this is because a lot of people may not want to work in D.C. Right. So in order to get industries, our choice was at first, and this was before we have nationwide workforce, because now we have a program called telework, and you can work anywhere in the country after 2 to 3 years. So you go to D.C. for 2 to 3 years, and you keep your salary in D.C., which is one of the good things. So you get paid as if you live in D.C., but you can live anywhere in at least the 48 states. I'm not going to say the other 2. But the satellite office are going to be mini patent offices. Examiners are going to go to that office. They're not going to have the budget and all that, but they're going to put examiners there because the concept was we can go to places where we're looking for a good workforce, where they have good universities, where they have technology people, and where its cost of living is reasonable. So our first choice was Detroit. A lot of different people that have come in for the other two sites. California wants one. Oregon was seeking one. Minnesota, Texas, New Mexico, Georgia. So as you can see, there will be somewhat of a desire to put 2 and 3 in their state. We have to figure it out, and it's not going to be easy.
I wanted to thank you for the opportunity to listen to your discussion. I also had the additional benefit before your discussion here in the courtroom with us today to meet you and talk about a few things in a sideline discussion, and something that came up in there that I think would be beneficial for those of us that didn't get that opportunity or anyone else that might be participating via webcast. My undergraduate degree is in political science and international studies, which a friend of mine recently told me would do me a lot of good in Philippi, West Virginia. I know there's this perception that I can't work for you. There's nothing I bring to the table because I don't have this scientific background. And I know that was something that came up earlier. And if you would, please, could you explain what somebody without a scientific background, what opportunity or what I might be able to bring to the table in this field as it's growing and becoming more and more important to us?
And thank you for the question. I think that's a good inquiry for everyone, that there are opportunities, not only my agency, which is USPTO, but government-wide. I think the federal government offers a lot of opportunities in order for attorneys who want to go further their career in regulation, and then ultimately maybe they want to decide to go private. What I will say about our agency, and personally, is we're an agency of over 9,000 to 11,000 employees. Of that, we have a budget of 2.7. So we have, like any personnel system, we have many lawyers with many needs. We have attorneys that need to go to court to actually represent us in court. That's our solicitor's office. There is no requirement that you have a technical or science degree to be an attorney at the Office of Solicitor of the USPTO. We also have the Office of General Counsel. The Office of General Counsel deals with contractual procurement, employment, all those issues. None of that requires a technical or science degree as well. We also have the Office of Finance. So as you would imagine, when you have a big organization like that, you're going to have special needs for attorneys in numerous fields. And provides different opportunities, not just for what perception is strictly techie, hardcore science people. Although we do need that, that's not all we do use. So I think that gives opportunities for many people, and not just at our agency, at all federal agencies, which across the country.
Thank you for coming today. I just had a quick question on what you believe. I know there's a backlog, you said, of approximately 700,000 patent applications. What's the biggest time? What's the biggest time delay for someone from filing an application to receiving the patent?
I actually think the biggest delay is getting to the first action. And the reason for that is because there's so many. When you're taking them in order, when you have a workforce of 9,000 and a backlog of 700,000 in at least 700,000, it's just how many can you process and how many that you can do in a year competently, effectively. Because remember, when you grant this right, what you're granting is a right, a property right, or a right to exclude others from making, using, selling, offering to sell, or importing. So by having this right goes a lot of consequence. So we want to make sure that we not only do it, and we do it efficiently, that we also do it so that it's of scope that's proper and required. So I would say just getting to the action is the first. Once it gets opened, I think you can ask the professor who has prosecuted a lot of cases. Once he sees the first action, it generally goes into a 2-4 month cycle. But getting the first action in some cases, and I think some industries may take as long as 36 to 39 months. So that is why the need for some of these specialized programs like prioritized exam to get to the front of the line in case you need, because what the industry is saying is, man, if I just get my patent, I have people that want to invest. So I have to get the opportunity. So we have to create ways and mechanisms for people that have that much of importance so that we can actually see that application. And that's the types of things. When you have a backlog of that many, in some ways you have to create specialized, prioritized programs in order to see the ones that actually need it soon. Because some industries don't want a patent that quickly, issued that quickly. There's some that want it right away, because the lifespan of that technology, if they don't have it, may be gone by the time they get a patent. Whereas the chemicals and the hard sciences may not be concerned because they will enforce it over the life of the full 20 years.
And I guess just one follow-up is the prioritization track. Do you think that'll hurt, the ones that are in the backlog currently, or?
That's a very good question. That is an excellent question. The answer to that question is it should not. And the reason is the money for that program is supposed to be a set-aside in order to hire more examiners. The quid pro quo of the cost was the money would go for the hiring of the examiners in order so that no one falls farther behind the line. That is the concept.
One more question. Again, Mr. Frese, thank you for coming today. Undoubtedly, with America's situation and economic situation right now, innovation is going to play a large role in bringing our economy, as well as the world's economy, out of this recession. And given China's reputation with IP theft and their lack of a patent or a solid patent system, and other companies to be able to redress the IP theft, does the AIA or mechanisms in place address this theft problem, this IP theft problem?
This is more of a domestic. I wouldn't say, I'm trying to think of any of the areas that would have impact. One of the areas of impact to study is we're supposed to study whether or not that we should subsidize to some extent the cost of our small inventors if they go overseas to file. That may have a de minimis impact, but the real question is, will they enforce our intellectual property that we get in their country in mutual enforcement? I can say they have really stepped up their effort, and Congress is aggressively required that they enforce our intellectual property rights. So there is a real focus on that we get basically our IP protected in their country. I do believe they're making an effort forward. I think there's more to do, in my personal opinion, but I do believe that it's on everyone's agenda. The president raised the issue when he was in China. Everyone raises the issue. The bar associations raise the issue. Everyone is raising the issue, and they're also a member of WIPO, so there are some international agreements that they have to abide by as well. So, and also a stricter enforcement. We are really, really strictly trying to demand enforcement inside their territory of their own patent laws, which we require.
Thank you.
Sure.
Thank you, Attorney Fries, for this excellent information. And 2 points before I turn it over to the students, and that is, number one, yes, the Entrepreneurship Law Clinic here at West Virginia University is a pilot project of the doing trademarks with the USPTO. And then the second point is that in the future, we do hope that the USPTO considers West Virginia as a future examiner office as well. So I'll turn it over to the students who have something to present to you.
Mr. Frese, on behalf of the West Virginia University College of Law Entrepreneurship and Innovation Program, we want to thank you for coming out and sharing in our celebration of Global Entrepreneurship Week, and we present to you this small memento of our appreciation. Thank you very much.
Thank you, guys. I can say I've enjoyed being here, and I hope to come sometime in the future. Thank you.
Thank you so much. There are so many people to thank for this event. I mean, of course, there's co-sponsors, WVU College of Law, the students and faculty in the Entrepreneurship Law Clinic, and Professor Tu's patent class, and Professor Megan Anito's externship program, the Career Services program, and the Benedum Foundation that provides the seed funding for the Entrepreneurship and Innovation program. So we'll have a break right now, and it's a break for lunch. There will be a lunch in the other room in the Davis Gallery, and we will reconvene at 3 o'clock for those of you who are interested in learning more about and specifics about careers at the USPTO. So thank you all for attending.